to give a quick plug before we get too deep into any discussion for the Progress Center's law-related modules. So we've already released one. It's the Introduction to Federal and State Laws Impacting Students with Disabilities. And so you can read a little bit about it there. I also just kind of wanted to give a quick plug. It's part of an overall law series. And so we have another one coming out very soon. It's going to be Understanding the Sources of the Law. And so that one's going to get a little bit deeper into identifying and describing primary sources of law in the US. Kind of teasing out the relationship between federal and state law a little bit more. And how it relates to special education, and then really understanding the impact and role for sources of law with or for students with disabilities and their families. So you can go to promotingprogress.org and learn more about our modules there. And feel free to reach out to me with any questions. I'm happy to answer as well. And I can drop my email in the chat as well as some links here in a minute. So with that, I will turn it over to David and Mitch.
Okay, well, thank you very much, Nick. What David and I are going to be talking to do today is providing a free, appropriate public education, lessons from the due process hearing front. And in a later slide, we'll talk a little more about our experiences in conducting due process hearings. But I wanted to first start with the definition of free, appropriate public education. Now, that, as you know, is the primary requirement of the Individuals with Disabilities Education Act. And our crucial obligation as special educators, that is, we are to develop individualized education programs, or IEPs, that provide a special education and related services to our students that confers a free, appropriate public education, or FAPE. And so we'll be probably mostly using the term FAPE in future slides. And the next slide, you can see this is how the federal this is how Congress defined FAPE way back in 1975 in the Education for All Handicapped Children Act. It is still a definition that is used in the Individuals with Disabilities Education Act, which of course is just the new name for the Education for All Handicapped Children Act. At any rate, in 1975, Congress defined FAPE as special education related services that are provided at public expense, meet the standards of the state education agency, include preschool, elementary, or secondary education, and are provided in conformity with the IEP. Now, let me spend just a few minutes talking about those. That means public expense, of course, means what we put in the IEP. Parents do not have to pay for that. It's at public expense. It meets the standards of the SEA. That means if your state you live in has any requirements or rights and responsibilities given to youngsters with disabilities in excess of the federal law, you have to follow those. So, for example, in South Carolina, where I am, the federal government says transition services must begin at age 16, but in South Carolina, our law says they have to begin at age 13 and a half. So in terms of transition, we have to follow the state law because it actually provides greater rights than does the federal law. And the final one is provided in conformity with the IEP. Now, this, of course, is the document that is the blueprint of FAPE for all youngsters with disabilities. And you can see it doesn't really define what appropriate is very clearly. And that was purposeful. As you can see in the next slide, one of the co-sponsors of the idea, a fellow named Robert Stafford, was a senator from Vermont, wrote an article in 1978 in the Vermont Law Review in which he said, we congressional authors of the idea did not attempt to define appropriate, but instead we established a baseline mechanism a written document called the IEP, or Individualized Education Program. So in other words, they did that deliberately. They didn't want to define FAPE for a given child. They wanted us as the special educators to define what a FAPE was. Now, if we go on to the next slide, what we'll see is that we have a decision in 1982, not too long after the Education for All Handicapped Children Act was passed. We had a number of cases occurring trying to define what exactly is this thing called a FAPE. And in about 1981, one of these cases, a case out of New York, was submitted or appealed to the U.S. Supreme Court in 1982. The High Court decided to take on the case of Board of Education of the Henry Hudson School District v. Raleigh. So that was a very important case because, as you know, not many cases that are appealed to the Supreme Court are heard by the High Court. And in fact, this was the very first case in special ed. And unlike the court, the Supreme Court essentially is asked a question to answer, or a question or two. And the question presented to them, well, what is the level of educational benefit that schools must confer on children with disabilities to provide them with a FAPE as guaranteed by the Education for All Handicapped Children Act. And so that was the question the High Court sought.
Okay, there. Okay, keep going, Mitch.
Okay, essentially, what is a FAPE? And the Supreme Court answered it by ruling on this case. And in fact, they ruled that the Henry Hudson School District had provided a free appropriate public education to Amy Raleigh. And they developed a two-part test where all hearing officers, all judges, when they hear a FAPE case, have to answer. The first part of the test is, has the state or the school district complied with the procedure set forth in the law? And the second is the following: is the resulting IEP reasonably calculated to enable the student to receive educational benefit? So the first part of the test was kind of a procedural litmus test where the hearing officer would look at how the school district had proceeded with the FAPE to develop the child's IEP and ensure that they followed the procedure set forth in the law. If the court was, or hearing officer felt the procedures were set forth, then they would go on to the second part of the test. Is the resulting IEP reasonably calculated to provide educational benefit? So in the next slide, we'll have David take over, I think.
So what's important about this case is that the Raleigh case is pretty much probably the case that many of you had when you were going through your training to become either teachers or building level administrators. That was the case that defined what we meant by how much progress or benefit a child is supposed to make. We put together this map, and I just want to make sure that you understand, yeah, this map is not drawn to scale because Guam is nowhere near Alaska. But it's one thing that you need to pay attention to is that as a result of the Raleigh case from the 1980s is that bad cases sometimes make bad laws. And why we talk about this is think about your special education population that you deal with. And I mean this literally. Think about the prevalence numbers of which you are expected to address. What's important about this is Amy is deaf. And she's had a higher IQ, or IQ, depending on which test and which determination you listen to, it could be somewhere between 130, 142. I'm willing to bet that the vast majority of kids with whom you work with are not deaf with high IQs like this. And that is a very small number of kids that we're dealing with. And as a result of that case from the 1980s, which was written by the Chief Justice at that time, Rehnquist, is what they came up with. We came up with very different standards of how this was being interpreted across the United States. And you can see, depending on where you live, Mitch and I both now live in the Fourth Circuit. Up until a few weeks ago, I lived in the Third Circuit, which had a higher standard, but I recently moved to the Fourth Circuit. But it's interesting about this, you can see higher standards versus lower standards, and that posed a significant problem. And when the court heard this, decided to hear this case, the next case, which we're going to talk about, one of the factors that we need to pay attention to, it shouldn't matter where you live, the level of education your child receives. And I'll highlight this for you, because up until about 2 months ago, I lived in Carlisle, Pennsylvania, which is home of the U.S. Army War College. And what's interesting about that is we got colonels from all over the United States, or colonels to be, from all over the United States coming through War College who had kids with disabilities and talking about how very different the standard was in different locations. And it was really palpable with the problems that they had. So we had differences. We had a bad a case. Yes, you probably studied when you were going through your training program, but what it did is it didn't clarify enough to provide consistency across the United States. So we needed a case to help us clarify this. This, in addition to the standard for education had changed from 1982. Think about this. Since 1982, we've had the expectations of what we're supposed to do with kids with disabilities has risen. I mean, the expectations, kids with disabilities are eligible for special education now take the same standardized tests as everyone else because the accountability measures have changed. We had Goals 2000. We've had multiple reauthorizations of the law. We're still waiting on another one, but we've had multiple of these reauthorizations that helped move the case and raised what's going on. You have to remember when the Raleigh case was basically heard, one of the quotes that they used to describe this was that the law was a basic floor of opportunity. Now, child find is not really a big issue. We're getting kids in schools. And what we have to think about is what can we do to provide appropriate services? So we needed a case that helped with this. So the Supreme Court took this, and they took this case out of Colorado. And these are two pictures that I took when I was in Colorado, 2 different times, not the same time. And I'm not trying to imply that one is a snowy place and the other one's a green place, but it just happened to be from 2 different visits to the fair state of Colorado. But you can see this. Summit View Elementary is where Drew went to school. It's located in the school district just immediately south of Denver. If you go down I-25 and you see Castle Rock off to the left, that's the school district. If you were to go to around the left of this building, you would see the skyline of Denver in the background. His parents, he was attending this school. And what's interesting about this is he pretty much had the same kind of level of expectations, same kind of goals, no real progress. And he was also more consistently with what we're experiencing in special education. He was an individual with a behavior problem. He was autism. He had a lower IQ. He had attention problems, much more reflective of what we needed than what we had with Amy Rowley. So we needed this. His parents were dissatisfied with the program that was being offered by the local school district, and they enrolled him where it's green and the flowers are blooming at the Firefly Autism House. Again, it was a winter picture versus a summer picture. I should do better next time I'm out there. But they enrolled him in a private school in southern Denver and sent the tuition bill back to the school district because they felt that they were not receiving an appropriate education. And what's interesting about this is they went through that to get to the Supreme Court, you have to go through the process. And Mitch is going to talk about this process in a few minutes. And the fact why we're talking about this is because we both have served in the roles as hearing officers. And what we talk about this is that parents went through the hearing officer list through the process, went through the hearing, went through the circuit courts, and then went to the 10th Circuit. And you can see the 10th Circuit, the 10th Circuit's mandate at that time is when we have to think about this must be more than de minimis. And so we'll talk about this in a minute. But they have parents. They were not winning. And it's interesting about this. I've worked in a lot of lawsuits, and if I'm working with a parent and we lose at the first tier, with the administrative law level, at the court level, and at the circuit court level, the fact, do you think you're going to appeal and win? Chance on this one. The parents appealed. The parents appealed this to the Supreme Court, and this was the question that was presented to them. Okay, and it's interesting about this, and I want you to pay very close attention to the verbiage of this. What is the level of educational benefit that school districts must confer on a child with a disability to provide them with a free, appropriate public education as articulated by IDEA? How much benefit, or progress was a child expected to make? Because the law says, as Mitch articulated earlier, we're supposed to provide individuals eligible for special education a free, appropriate public education. Appropriate is very much in the eye of the beholder. I'll give you a visual representation of this. And I just want you to think about this, is in the March, right before COVID, and we refer to affectionately as the pre-times, I was doing a speaking tour in Southern California, and I was happy to be there during spring break week. There were people wearing things that I did not feel were appropriate. And we don't have images to share with you, but I want you to have this analogy, is that I have flossed with more things that are wider than what they were wearing. So what is appropriate is often very much in the unique needs and take of what an individual thinks about. And so that has been one of the big disputes that we have in special education. So maybe we should get a picture of that one for the next presentation, Mitch. What's interesting about that is, so they appealed it, and they heard oral arguments on January 11th, 2017, and there we are. We have both lost weight since then, by the way. And so we're fitter, stronger, faster. But what's interesting about this, and I mean that we are, is what is interesting about this is at that time, there were only 8 Supreme Court justices. They had not seated a replacement to Justice Scalia, who had recently passed away about 10 months prior to that. But then they issued their ruling just 2 months later. And what's interesting about this, and I want you to pay attention to this, is because it was a unanimous decision. And there are rare unanimous decisions from the Supreme Court. And I want you to understand, with the unanimity that they presented this as a part of this. So what they rejected, and the Supreme Court very eloquently rejected, and those of you who would like a copy of the decision or the FAQs from the Department of Education, don't hesitate to reach out to me. I'll make sure you get a copy of these. But it really is worth reading. They rejected the merely more than de minimis standard and vacated the decision and remanded back. But what you have to think about this, and it was Chief Justice John Roberts who wrote this, a very good writer, by the way. But read this, and I'm not going to read things to you, but I'm just going to make sure to emphasize this part to you. Is to meet its substantive obligations under the IDEA, a school district must offer an IEP recently calculated to enable a child to make progress appropriate in light of the child's circumstances. Remember, under the Raleigh standard from the 80s, it was benefit. Now we're expecting kids to make progress. And what we've seen as a part of this is changes as a result of this. And that's what's happening. So we are expecting kids now to make progress in their special education. And that's what's important. And that's what important. We need to pay attention to this as we move forward this. Okay. But here, and we highlighted some phrases from some words from this. Maybe you can figure out which words we've specifically highlighted for your entertainment value. But the IEP must enable the child to make progress. Think about this. And pay attention. The essential function of the IEP is, I'll skip the non-highlighted parts, to make academic and functional advancement. It's not just academics that we want kids to make. We want kids to make functional advancement on things, so that they include and social advancement. We want them to improve on just their ability to interact with others, and also to get around and participate in what's going on in the school. So these are two very important things, more important things we need to pay attention to as a part of this. Now, and so what's interesting, I want to make sure that you understand, is that the Raleigh standard that Mitch articulated has been tweaked, and is tweaked by the scene like this. So what we refer to this now is the Raleigh-Andrew two-part test. And this is, first, has the state complied with the procedures, okay? Has the state complied with the procedures set by the law? This is why your special ed directors hound you to make sure you follow the timelines, that you have the people in the right room, and that you have everyone in there, that you have all the information by the right time. This is very specific, and this is not going to change. And it's still part of this. What is the rationale behind this? Is if we follow fair procedures, we're going to get fair outcomes. That is in part what we're expecting as a part of this, that we need to follow fair procedures and follow this so we understand precisely what's going on. The second part of this test, and this is the subtle wording difference, is the resulting IEP reasonably calculated to enable the student to make progress appropriate in light of his or her circumstances. And what's interesting about this, as we were sitting in the oral arguments, Chief Justice John Roberts, and if you get a chance, by the way, to listen to the oral arguments, you can listen to that at oea.com. And it really is, it's an hour well spent of your time. is he was actually very prescient in asking, what about kids who have significant disabilities? What can we expect? What kind of progress can we reasonably expect for them to make? Because in the end, the parents, even though Drew had a significant disability, the parents were expecting all individuals to make the functional equivalent of a year's worth of progress every year. And so he kept asking this, and you can see how the language came out of this as a result of this. Is where we go with this is the appropriate progress appropriate in light of his or her circumstances. So it has to be individually tailored back to the child and back to the individual needs of that child. We'll make some recommendations in a few minutes about this, but you can see this as they remanded this back. They remanded it. And we can see back, and they remanded back down to the district court and said the IEP was not appropriately ambitious because it did not give Andrew the chance to meet challenging objectives. I mean, the goals were not really that strong. I'm couching my words there. I mean, I could use other words, but they just didn't give him a chance to do this. So one thing you have to think about, and we'll talk about this later, is ensure that you're providing the opportunity for kids to get ambitious goals and ambitious movement towards those goals. Okay. And you can see this after 7 years of litigation, the Douglas County School District paid quite a bit of money to settle this case. And so I know most of you probably have an extra $1.3 million laying around, but for some people, that's a lot of money. But it's really interesting how this works is that in the end, this has changed the standard for every single kid across the nation who's eligible for special education related, every single kid across the nation and its territories who are eligible for special education and related services. And the impact of this is dramatic. And so what we would like to talk about now is shift the gear since then, basically first how to litigate this and then some recommendations based on that, kind of go from there. Okay, so Mitch.
Okay, thank you. Well, so what I'm going to talk about is litigating a FAPE. Now, as I mentioned before, and David mentioned, both of us have had experience as due process hearing officer. We'll talk about this a little bit later too. But if I did a FAPE case prior to the Andrew decision, I had to use the Raleigh test. That was what I used to decide the case. If I decided a case on FAPE after Andrew, I used the Raleigh-Andrew test, because all lower courts hearing officers have to go by the law of the land, and the Supreme Court is the law of the land. So this was an extraordinarily important decision. Now, if we go on to the next slide, what we'll see is that there's kind of a typical way that the courts work in the United States. We have 94 U.S. district courts. Every state has between 1 and 4 district courts. Smaller states like South Carolina have 1. Larger states like, say, California will have 4. Now, when a case is heard at the district court level and the party that loses wants to appeal it, they then appeal to the next higher level of courts, which are the U.S. Courts of Appeals. And then if the party losing at that point wants to appeal, they only have one option, that is to the U.S. Supreme Court, which of course is only one in the United States, and that becomes the law of the land. Now, if we look at the next slide, that is a graphic again of the geographic boundaries of the United States in terms of the district and federal court. So if you look real closely, say at South Carolina, you would not see any dotted lines. That means there's only one district court in South Carolina. But if you look at California, you'll see there are 4 district courts. Now, when a case is heard at the district court level in South Carolina, that's a really important case for South Carolina, maybe not so important for California. However, when a case is appealed, it goes to the next higher level, which are courts that contain multiple states. So you can see the 4th Circuit includes Virginia, West Virginia, Maryland, North Carolina, and South Carolina. So if there's a decision out of Virginia that's appealed to the next higher level, that goes to the U.S. Circuit Court of Appeals for the 4th Circuit. So that decision is very important for all those states. It's not as important for those states in the 9th Circuit over by California, because they have their own circuit court. And so it's just important to understand that when that case, the circuit court is appealed, that goes to the U.S. Court of Appeals or the U.S. Supreme Court, which covers the entire land. It becomes the law of the land. Now, our system in special ed is special, works a little bit differently. And in the next slide, you can see how it works differently. We have a due process hearing system set up in the IDEA. There are actually two different types of hearing systems. Most states have what is called a one-tier hearing system, like Virginia, where the first level of hearing is at the state level. We in South Carolina are a little different because we have two tiers. The first is heard at the local school district level by the due process hearing officer. And as David will tell you, and he's done many of these when he was in Pennsylvania, it's like going to court. I mean, you have both sides represented generally by attorney, and although not always, sometimes parents will go pro se, which is they argue their own case, but there'll be attorneys on each side will examine witnesses, and the other side then will cross-examine. It's like going to court. And then the hearing officer generally has 45 days to issue their ruling. The losing party then can appeal to the next level or the state level review. There's only 7 states that have that, and I think it's 6 now. One of them is South Carolina. That's what I do now. Review those. And if the losing party at that point wants to appeal, then it goes into the U.S. District Court. Now, attorneys could go the federal or state way, but 98% of the time they go federal in terms of IDEA cases. So then it goes into your typical system: U.S. District Court, U.S. Court of Appeals, Supreme Court. But what David and I want to talk about more today is what happens at the hearing levels. So on the next slide, you'll see that in terms of hearings, in terms of the hearings, we both have quite a bit of background in that. David, did you want to tell a little about the hearings you heard in Pennsylvania and your background?
Yes. So for 10 years, I was a first-year hearing officer. And at that time, the Pennsylvania had a 2-tier system. And I was the first one. I would be the one who would actually go into the local school district. Often you sit in the school board office, school board room, and then I would then hear the hearing and then make the decision. And over the 10 years that I was a hearing officer, I was assigned just shy of 600 due process hearings and had to write decisions on multiple topics. And then when Pennsylvania changed to just a single tier is when I just started working with school districts and parents when they were part of lawsuits. So that was about 10 years ago. Yeah, and Mitch has been a second tier, and so as he's going to talk more about that, there's probably not a topic that we haven't heard, given the hundreds that we have participated in. And so some of you watch Netflix, some of you and understand who Inventing Anna is, some of you understand, you watch Hulu and know what happened at the bottom of the stairs in Durham, North Carolina. Mitch and I do hearings. That's what we do. So
now, David, he acted basically as a judge. Very similar role to a judge in controlling the hearing and in deciding how it would go. Now, that was David's background. My background was I started out as that, but I switched to a second tier hearing, which means if the first tier hearing is appealed, it goes to me, and I just sit down on my dining room table with 1,000 pages of testimony and briefs and probably about 80 or so exhibits. And I have to decide, did the first tier hearing officer make his decision correctly? So that's what our background is in hearings. Now, it is important to understand that hearings don't really set precedents. And it's not like a case in the federal system that we all have to perk up and pay attention. Nonetheless, it's very important that we understand that hearings really are a harbinger of things to come. So David and I have written an article on COVID and how that's affected special ed. We haven't had a lot of cases on COVID yet because they're still really at the hearing level. it takes time for them to percolate through the United States courts. So it's thus very important that we do pay attention. It's also very important that we understand that hearings are costly. School districts can pay, there's an average of $10,000 to $50,000 per hearing. So they're very expensive procedures. I mean, you have to have a lawyer. The lawyers interview teachers. And what David does now is help prepares witnesses. That costs money. So it's a very expensive procedure. And hearing officers can decide on a number of remedies. They could decide on tuition reimbursement or compensatory education. The only thing they can't decide is attorney's fees. That has to be decided by a court. So, but nonetheless, we need to pay attention to hearings. And what David and I have found over our years in being hearings, in the next slide we'll see, is that there are a number of issues that have been very important. The most serious school district errors, and we've divided them into procedural errors, substantive errors, and then implementation errors. Remember, for the procedural part was the first part of the Raleigh and now the Raleigh-Andrew test. Did a school district follow the procedures of the law? And so as David was telling you, that's why you spend a lot of time at the beginning of each year talking about the procedures that your school district uses, because if you make errors, these errors could in and of themselves lead to a loss in a due process hearing. But there's three major errors that we have found that are procedural that school districts make. One is failing to involve the students' parents in the IEP formulation and monitoring process. That's perhaps the most important procedures, and really the reason for the procedures is we need to involve parents in IEP formulation and also in IEP monitoring and the whole aspect of IEP development and implementation. A second major error we found is predetermining program replacement. The first error is when schools don't involve parents. Now, I know as a teacher for 16 years, sometimes it's difficult to get parents involved. In that case, you have to make certain you document that you make good faith efforts to get the parent involved. The second error really involves school district personnel predetermining a child's program or placement prior to actually having a final meeting. So predetermination doesn't mean that you can't get together informally and talk about the IEP meeting. It just means you can't finalize the IEP and give it to the parents and tell them this is what we're offering and take it or leave it. A third major area, and one would wonder why this is difficult, is failing to properly conduct child find activities. And that essentially, that problem usually comes from schools knowing that a child may have a disability, but not evaluating that child. It's very important, if you believe a child with a disability, that you conduct an evaluation. You get the parents' permission to do so. As Julie Weatherly often says in her presentations, is when there's a debate, evaluate. So those are the three major procedural errors that we find. Also, sometimes schools will just make a number of procedural errors that in and of themselves can lead to a denial of FAPE. Now, the second most serious type of procedural errors are what we call the substantive errors. That has to do with the content of the IEP. Is the IEP internally consistent? That is, did you do a good and thorough assessment? Did the assessment lead to the present level statements? Do the present level statements lead to services or goals, or both services and goals in the IEP? A second major problem is failing to craft measurable annual goals. That's a very important problem that we have to remember. Since 1990, the law has said measurable annual goals. So we have to have a way to measure them. And so what I always like to say is that if your goal cannot be graphed, it's not measurable. And thirdly, failing to collect and or report data on student progress toward the goals could be a very serious procedural error. Now, if we go on to the next slide, you'll see that we have a quote there. A number of years ago, actually in 2015, I was at a law conference and attended a session by Kathleen Mayfield, who's attorney for Reed Smith. She just retired. David, I think your father used to live close to her. She was a school district attorney that specialized in FAPE cases and only represented school districts. And she made a statement that really struck me during her presentation. She said, when I have a school district with a FAPE case, the first thing I do is go to the teacher and say, give me information on your student's progress. If the teacher doesn't have data, I strongly consider advising the school district to settle. And that was in 2015. I actually went up to her after the presentation and said, do you mind if I quote you? And she said, absolutely, go right ahead. So think about this. This is a person who only represented school districts. And that was the first thing she asked for. Where's your progress data? Very important. And that was 2015, 2 years before Andrew, which now requires that the IEP be reasonably calculated to enable a student to make progress. Now, in the next slide, you'll see that we have found there's another type of errors that are frequently committed by school districts. And these are what we could call implementation errors. And that just means the IEP has been agreed upon, everybody's signed, the parents have signed permission for placement, the IEP is put into action, but the school district doesn't fails somehow to implement it as written upon. A few years ago, immediately after the Andrew decision, a very important decision out of the Ninth Circuit, the court said, the IEP, like a contract, embodies a binding commitment and provides notice to both parties as to what services will be provided to the student. We have to understand the IEP is like a contract in that it's binding. We're saying this is what we'll provide, and we make good faith efforts to provide those. It's not a contract in that it's not a guarantee of success. Rather, again, it's guarantee that we will do our best to meet the obligations that meet the obligations in the IEP. And in fact, courts have found that material errors in the IEP development, all but one circuit have decided material errors in IEP implementation will result in the denial of a FAPE. So what we have next is we're going to talk about, based on our due process hearing experiences, what do we recommend? And David's going to take it from here.
Okay. Thank you, Mitch. And I appreciate the opportunity to tee it up like this. And what's interesting about this is Mitch and I are involved in a lot of litigation across the nation. And what we rarely are often brought in is after there is litigation or there's a crisis. And what this is a chance for you to hear, for lack of a better term, prophylactically, something to prevent things down the way and to take this and use this. And we mean this literally, is that the steps and the next things we're going to be making as recommendations are things that you can take back to your school district or division to provide appropriate supports to hopefully prevent kids and parents from having to go to litigation. Mitch and I will talk about this multiple times and in multiple venues, is that we are strong opponents of litigation. We want people to settle. We want people to get along. We wish there did not need to be litigation. But we have to remember that special education is a field defined by a law. And it's often very emotional for the parents who have a child and they want what's best for their child. And as I said before, our obligation is only to do what's appropriate. So we have to pay attention to this as we go through this. So these are recommendations that we have learned from just all the, I mean, I haven't read a due process hearing decision since this morning, so I'm a little out of touch. But what we'll do is we'll try to stay close to date with where we are with this. But we really think these are recommendations that will be valid for you and your district to help solve problems down the line. Okay, so take each one and pay attention to these. And we're not trying to talk down to you. We're just trying to be consistent, because We realize that most of you are dealing with new teachers, and most of you are dealing with untrained teachers, most of you are dealing with untrained paraprofessionals, and many of you are dealing with new principals. What's the statistic is that 1 in 4 principals across the nation changes this past year. So keep that in mind as we go through this. So what are we doing? Work to understand the procedural violations that could in themselves constitute a denial of FAPE. And we mean this literally. Get the right people in the room. Get the right information. Build a really good present level statement with information from everyone who interacts with that child. Make sure I get a statement from the bus driver, get a statement from the supervisor from the playground, get a statement from anyone who interacts with this child. When I help with cases, I make sure that there is no stone unturned, that we talk to everyone as a part of this, but make sure that you have good information and could do anything about this from everyone who's a part of this, but pay attention to this and get it in a timely fashion, okay? And second, and I can talk faster, I come from a family of auctioneers, so bear with me. It's interesting about this, okay? When developing the content of the student's IEP and subsequently reviewing it, make sure the information you have about this child is current. The word present means present now, not like last year or 2 years ago or 3 years ago. Yes, have that information, but make sure that it's included as what we are talking about this. I can't tell you how many times I've reviewed IEPs where they have done a whiz-bang, wonderful review, finding the child eligible for services in 4th grade. They cut and paste a lot of that information to the present level statement, and that's there for 4th grade. It's there for 5th grade. It's there for 6th grade. It's there for 7th grade, and there's no information from this 5th or 6th or 7th grade teacher as if the kid has not made any progress in the past 3 years. Make sure it's from current information. You have understanding of where we are with this and understand precisely what's going on with this child, that it's current information. I can't emphasize that enough, okay? Wait, there's more, okay? Is ensure that the IEP goals are appropriate, ambitious, and measurable. I mean, if you need to say it if you need to say measurable with marbles in your mouth, go for it, but it's got to be measurable. Mitch highlighted that before. What I say to districts, if you can't count it, don't do it, and it doesn't count. I mean, if there's not numbers, I'm a huge fan of what's referred to as interocular analysis. I want to eyeball the data and be able to determine yay or nay about whether the kid is making progress. People say it's like it's too litigious. You have the data. You have the data. And make sure that you take frequent data points on this and understand what's going on this, which I'm getting ahead of myself, but it makes sure it's measurable and make sure it's things like this, because I've seen IEPs where the child will think about writing, okay? I'm thinking about writing right now, but you can't measure it. So you understand this. You got to make sure it's something that's it's clearly measurable. Number 4, okay, is continuously monitor and measure a child's performance on annual goals and maintain data to demonstrate that progress has been made. Now, what's interesting about this is I worked with the school district in the pre-times, right before COVID, that was taking progress monitoring data only 1 time per marking period. I asked them to graph that, and they dutifully drew the XY axis, gave me a data point, and said, is that going up or down? And they said, well, it's right here. I said, it doesn't tell me anything. So what we need is multiple data points per marking period. And so what's interesting, people saying, well, we're just going to test the child all the time. No, there's a difference, and I want to make sure that you use this analogy with your teams, is understand the difference between a series of snapshots versus long videos. Take a series of snapshots, a 5-minute probe here, a 6-minute probe there on something, graph that data, and graph that as opposed to thinking you have to take a 2-hour-long test on a child. Give a series of snapshots that can move forward on this and help with this so we have some sense. And how much data? Well, hold on. When I do witness prep, I love witness prep with speech paths because they have data from every single session. And I mean this literally. They have data. It's wonderful. It's easy. I'm talking probably in a 9-week marking period, I'm thinking probably 6 to 7 data points. Because if you only have 3, kid misses 1 of those data points, you're down to 2. Yes, 2 to find a line, but it doesn't tell me the trend of where we're going. So I'm continuously monitor and measure so that you understand precisely what's going on in this, okay? Next, provide frequent and systematic data-based reports to the student's parents on the child's advancement towards their goals. Make sure the parents are fully informed on this. And I mean this literally, is we can handle anything as long as it's not a surprise. And you need to keep the parents informed about how the child is doing, where the child is making progress, and what's going on, and then build on that so that they understand. For instance, my dad was a superintendent of schools for many years, and he hated the last week of school. He was in a very large school district, and he had 7 high schools in his district. And he hated the last week of school because he would get these calls from parents who, for the first time, would find out that their son was not going to graduate from school. Typically, it was a son, and they were not going to graduate. And they said, "We've flown in Granny from the West Coast. We have a cake. We have pictures of him in his cap and gown. What do we do?" Make sure parents are fully informed of what's going on. They were an equal part. We need to emphasize their equal part of this and keep them fully informed of where we are with this, but provide data on this. Now, some parents are going to ignore it. That's that, but we're going to still provide it. We're still going to have equal participation with them as part of this. Keep them fully informed about where they're going with this, because you don't know who parents are going to talk to. You don't know who parents are going to address, and you need to make sure that they are fully informed about where we're going with this. Okay, wait, there's more. Okay, here, and this is the most important one. Not that anything else is going to be less important, but this is the most important one. When I say that you should take regular progress monitoring data, as I did on the previous slide, you need to do this. But, and this is what's tripping up so many districts, and this would solve so much of the litigation that I'm involved in. How much litigation have I involved? I've been involved in, I think it was 93 lawsuits since the beginning of COVID. 79 of those we settled really quickly because we didn't have progress monitoring data. Why? You need to make sure you have progress monitoring data. But when you have progress monitoring data and you determine the child is not making progress, you graph this, you need to reconvene the team and determine why and make functional and academic changes for this child. And what does this mean by it? It's like I was involved in a case in the pre-times where we knew at the end of the first district, not we, not me, the district knew at the end of the first marking period the child was not making progress. 7th grade boy. They didn't do anything. They knew at the end of the second marking period that the child is not making progress. They didn't do anything. They knew at the end of the third marking period the child is not making progress. They said, well, it's too late in the school year. We'll just do it at the end of the year, and we'll do it for next year. This district knew at the end of the first marking period, this child was not making progress, and they did nothing. Who's the slow learner here, folks? And that's what I want to emphasize is when you have evidence of this, that the child is not making progress, do something. These children have disabilities at no fault of their own. And what we need to think about is what can we do to improve their lives so that they can continue to make progress and that they don't just flounder. It is our obligation. It's not only a legal obligation, it's a moral obligation to help and provide supports for these kids. And if we can do this and learn from this, we will do better for these kids. And that's what we want to emphasize, okay? So now we're going to talk about some additional resources and about that we have available for you that will help with this, okay?
Yep, so we're just gonna highlight really quickly, feel free to progress, David. There's a couple modules from the IRIS Center on developing high quality IEPs. And really those are gonna, give overviews of forming those according to federal regulations. So definitely make sure that you're checking with your state and local education agencies for additional requirements, but those are some really good resources. Feel free to progress, David.
Okay, well, just Nick, real fast is Mitch and I wrote the high quality IEPs one. There's one for teachers and there's one for administrators, and they're free. They're free resources, and they've been vetted by the U.S. Department of Education. We spent an enormous amount of time on them, and we think they're good. So, all right, okay.
And I can drop those links in the chat. I know that they're in the, there's links to each in the bottom corner there. So I'll be dropping in the chat here in a second. I don't know if you want to say anything more about the other one, David. But yeah, quick plug for the just reminder about Progress Center's most recently released module on the intro to federal and state laws. And we will be releasing a couple more within that series very soon.
Here's some additional resources for you also. And these are important places where you can go for this is all free stuff, folks. And we can't emphasize enough how important it is for you. And going back, let me just go back to those IRIS modules. that is actually could be free PD for your district, where you have the ticket in the room is you have your teachers do the IRIS module on legally compliant IEPs. It's the first one of those two. And then you sit there and you talk about what is this like in our district, and kind of go through things like this. The same thing for administrators. I'm doing some administrator trainings next week, and their ticket in the room is for them to have taken the administrator module and understand what's going on about this. It's being used in many states in multiple territories. But here are some additional resources for you that you can also benefit from and where to go with this. And these are all, again, free resources that you can pay attention to, and wonderful things, wonderful places that you can go for information about this. And I know a lot of teachers are looking at Teachers Pay Teachers or going to YouTube for information. This is all valid stuff. This is all good information that you can use and kind of help with this and go from there. Okay. So here's how to stay connected with the Progress Center. Okay.
Oh, yes. Feel free to connect with us on Facebook or Twitter. And we also have a mailing list available on our website, promotingprogress.org. And feel free, I dropped my email in the chat earlier. If you have any questions about those, feel free to get in touch.
Yeah, I'll put my email in the chat also.
Yeah, also,
and
I actually put a couple in there. There was a question about the presentation, the slides. Be happy, either David or I, if you want to email us, we'll be happy to send you those or any
they're actually available on the Progress Center website, and I can drop the link there as well.
Okay, just one last thing I wanted to mention is that one of the things that Chief Justice Roberts wrote in the Andrew decision is that school authorities can be expected to provide a cogent and responsive explanation as to why the IEP was reasonably calculated to confer progress in light of a child's circumstances. So I think the best place, and there was a question about how often should we collect data. David and I's standpoint, we always say collect it as often as you can. The more snapshots, as David said, we have, the better information we'll have. And if we have set up our IEPs in such a way as to have measurable goals, to have services based on the present levels, to collect data, we will essentially have bulletproof IEPs. Remember, an IEP is not a guarantee of success. It's a guarantee that the school district is going to make good faith efforts and make changes if need be to the IEP in order to confer a free, appropriate public education.
So just as a concluding comment, thank you, Mitch. That was very nice. I appreciate this. Is this whole day of sessions and this whole information has been sponsored by the Progress Center. And what's interesting about Mitch and I are senior advisors to the Progress Center, and I dropped my email in the chat. I think Mitch did too. But if I know we understand the nature of adult learning is there's been a lot of information just in the last 55 minutes. But if you think of a question next week, the following week, or next month, do not hesitate to reach out to us, and we will do our absolute best to find you get you a timely answer to this. I know I don't know everything. I had 2 teenagers for years who reminded me of that, but I know where I can get answers to questions. And Mitch and I are constantly throwing questions back and forth about how to interpret things. But if you have a question about this down the line, do not hesitate to reach out to us, and we will do everything in our power to get you a timely answer. But also continue to monitor the Progress Center, because what's going to be is there's going to be increasing information being thrown up there that will provide greater assistance to you and your team down the road. I can't emphasize that enough, is the opportunity for you to pay attention to what's going on. But if you since both Mitch and I work with the Progress Center, if you think of things down the line that you would hope that the Progress Center would like to step in and help with, let us know. And we'll run it up the flagpole, and hopefully can or those where we can get additional resources for you about this. But Nick, the individuals should be able to access the slides at the Progress Center website. Is that correct?
Exactly. They're available for download at that link that I put in the chat.
Yeah. No, thank you. So again, if you guys have questions, don't hesitate to reach out to Mitch and me. Mitch and I, we text each other a lot, so we know what's going on, so we can get you timely answers. And we mean this sincerely, because our goal is to try to prevent litigation. Our goal is to provide appropriate services so that you can spend your money on providing appropriate services to kids who need them, instead of having to spend your time on litigation and paying lawyers' fees. And so, and also to work to develop better relationships with these families who will be providing the long-term care for these kids. And so that is our goal. That's truly what we're focusing on. And that's one part what the goal of the Progress Center is, to help these kids make progress so we can understand where to go with this. Okay. So, all right. Okay.
Well, and
So-
thank you very much.
Yep.
Thanks,
So
everyone.
thank you very much. Okay. Enjoy your next session, but please do not hesitate to reach out to us.